Welcome back to the Friday 5 for November 10th, 2023. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Let's take about 5 minutes. We'll look at 5 quick questions from the week, maybe some legal questions you've wondered about before, and these will help get you started on your way to the answers you're looking for. Question number 1 this week: can I rent out my house without creating an LLC? So in this case, the caller actually had a pretty interesting situation. They've owned the house for many years. They've just had family members renting the house here and there. It's been in the family, things have been good, but now nobody else wants to rent the house. Everyone's moved on, and they want to create a rental property that can have some income for them. And the question was, do they have to create an LLC to be able to rent out a property? And the simple answer is no, you don't have to have an LLC, but it's often going to be a very good idea to have one. So as we create that LLC, we can rent out to a third party. The next step we want to make sure we do is create a rental agreement for whoever's going to be renting the property. We want to make sure that everything's in writing and that the LLC is a party to the rental agreement as well as whoever the tenant's going to be. If you choose not to create an LLC, then my advice is normally let's max out on insurance for the property. So the LLC will give you a lot of liability protection. It'll protect you if something happens at the property. But if you can't do an LLC, let's say your mortgage company won't agree to the transfer into an LLC, then your other option is to frankly create a property that has a lot of insurance on it so that you know you're protected. So if something happens, there's enough insurance coverage so it doesn't come out of your pocket to settle whatever the claims are. Question number 2 this week: does my LLC have to be an S-corp? So if you read anything online, you listen to podcasts, you read the blogs, everyone wants an S-corp. And we've talked about this before. An S-corp is not a type of company. An S-corp is a tax election with the IRS. It's a way to handle the income and distribute it to the owners of your company. So when you create an LLC, you do not have to make it an S-corp. And in fact, the default when you file an LLC is not an S-corp. It's a separate tax election that you or your accountant will make with the IRS for the company to be treated as an S-corp. So you don't have to be an S-corp, and if you don't want to be an S-corp, you don't have to be one. And frankly, if you have multiple partners in the business, an S-corp doesn't always make the most sense depending upon how we're going to be distributing funds from the business. So talk to your accountant. That's the important person in this process, and find out whether or not an S-corp election makes sense for you. And keep in mind that the S-corp election may not make sense for you today, but it might make sense next year or a couple of years down the road as the business grows and has different financial obligations, maybe takes on more owners. So this S-corp election is something that you can keep in the back of your mind. It doesn't have to be an S-corp when you form the LLC, but you want to make sure you understand when it would make sense for you and your company. Question 3 this week: can I sue someone a second time? So we see this in the movies a lot, and in the area of criminal law, it's the idea of double jeopardy. So if you've been accused of a crime and they try you and you're found not guilty, you can't then be tried again for the same crime. In this case, my client actually called me because he'd had a lawsuit that he handled on his own against somebody, and the court had entered a final order. And the question was, he had more things he wanted to say, and there might have been other claims that came out of that same transaction that the previous lawsuit had been based on. So he wanted to know, could he actually bring another lawsuit against this person, another chance to get money back from them as part of this transaction. In this case, what we need to do is look at that prior order and see what the language says. If the language says without prejudice, that means that you can actually bring another lawsuit because the claims have not been decided to their finality. In this case, however, my client's order actually said with prejudice. It was actually my client and the other party. They'd all submitted claims, and the court denied everybody and said all these claims are dismissed with prejudice, which means that neither my client nor the other party can go back to court and try to sue again on the same claims. Now, this is different than an appeal, so you may have a right to an appeal, and that's a different set of issues you want to deal with. Maybe a decision went against you and you want to appeal to a higher court. But this is where we're talking about bringing a new lawsuit on those same claims. If they've been dismissed with prejudice, you can't bring a separate lawsuit. Question 4 this week: what happens to my divorce if I have a prenup? So when you're dealing with the divorce area of law, a lot of times you're going to hear from your friends, your neighbors, other people. Maybe your cousin went through a divorce. It took years. It cost hundreds of thousands of dollars. There's all kinds of different stories when it comes to somebody's divorce action. And the thing you need to remember is just because it happened to your neighbor, your cousin, your sister, whoever, it doesn't mean that's the way that your divorce action will go. And in this case, my client actually has a prenuptial agreement that we had drafted years ago. And because of that, the divorce action is going to be a very streamlined situation. There are no children, there's no claims for alimony, and there's really no assets to be divided up because they were already outlined in the prenup what happens to those assets in the case of a divorce. So in this case, the prenup is going to streamline that process where we're just pushing documents. It's a New York case where we're going to submit a few documents, everyone signs off on it, no court appearances, we don't have to see a judge. Very simple, it's easy. The prenup can control the distribution of those assets and you can move on with your life. So if you have a prenup, it's very important that you understand its effect on any divorce action you may have in the future. And question 5 this week, if I move, do I have to update my estate planning documents? And we've talked about this before, and the real question is, where are you moving? If you're moving down the street, if you're moving to a different town, and you're staying in the same state, then chances are no, you do not have to update your estate plan documents because just simply changing the address doesn't invalidate them or anything like that. However, when you move to a new state, you want to make sure you're speaking to a local attorney and you want them to review the estate plan you have from your prior state to see whether or not you're taking advantage of the laws of that local state. So for example, if you're currently living in New York and then you move to Minnesota, New York does not have what we call a transfer on death deed that Minnesota does. And what that deed allows you to do is essentially create a beneficiary designation for your property. That's not available in New York, but it is available in Minnesota. So somebody moving from New York to Minnesota would want to meet with a local attorney, go over the estate plan and see are those advantages, things like a transfer on death deed, available in the new state that weren't available in the old state. So if there are no advantages and you just don't want to update your documents, that's fine too. You can keep your documents. They should still be effective for you. One area you want to watch out for are powers of attorney and healthcare directives. States usually have their own individual form, and it's a good idea to use the state forms for the form where you're living, just because the financial institutions, the doctors, the medical providers, they're used to the state forms. It just makes it easier for them to review them with you. So those are our 5 questions this week. If you like this video, you can hit the thumbs up below. You can hit the like button. You can head over to YouTube and check out ayerslaw.tv.com. There's a Friday 5 series, and we have other videos on business law and estate planning. There's also a link there to submit a question for future episodes, and you can always go to 𝙃𝙀𝙍𝙊𝙒.com for a legal strategy session or to learn more information. Wherever you are, I hope you have a wonderful weekend, and we will see you next week.